Good afternoon. Thank you for joining us for Beale & Company's Construction Law Update on Novation for Consultants. My name is Will Buckby. I am a partner of Beale & Company in the Projects and Construction team. I am joined by my colleague Ben Mollard, an associate in the team. Ben and I will be providing this webinar to you today. Before we start this webinar, I would like to deal with some housekeeping items. This webinar is scheduled to last approximately 1 hour. After we have progressed through the slides, if time permits, we can deal with any questions. You can submit questions to us during the webinar in the appropriate box in the right-hand side of your screen. Given that we have circa 100 people in attendance today, if you are able to, please can you mute your microphones. Finally, for the solicitors wishing to obtain CPD points for this webinar, we provide Beale & Company's CPD registration number on the final slide. The aim of this webinar is to provide guidance on novation for consultants and members of the professional team appointed in relation to a design and build project. We have chosen to speak on novation because in the current economic climate, we are seeing more and more projects procured through design and build. We are also seeing more issues and disputes arising out of novation. By way of an outline of what Ben and I will be speaking about over the next hour, we intend to provide an introduction to novation generally, describe the two main approaches to novation, the ab initio and switch novations, highlight the implications of novation for consultants, and then discuss the key risks arising out of novation and how we can mitigate these. Firstly, dealing with some basics. Under every contract, each party typically has various rights, such as a right to receive payment, and various obligations, such as an obligation to provide certain services. Rights can be freely assigned unless expressly prohibited in a contract. Once rights are assigned, the party to whom the right is assigned to will receive the benefit of those rights in place of the party who received those rights before assignment. For example, if a consultant's appointment is assigned by the client to a third party, the third party will be entitled to enforce the rights in that appointment. Importantly, obligations cannot be assigned. For example, a client's obligation to pay the consultant will remain with the client, and such an obligation cannot be assigned to a third party. Novation is different and goes a step further than assignment. Novation transfers the rights and obligations of a party under a contract to a third party. Novation is achieved by way of a tripartite novation agreement between the two original parties, so the client and the consultant, and the third party to whom the rights and obligations are to be transferred. Novation can arise in many different scenarios, such as in the context of a business sale or a change in client. Concentrating on the latter, the most topical is perhaps the Department of Transport novating or transferring its highways agency contracts to a new highways agency corporate entity, which has been well publicised in the recent trade press. Nevertheless, perhaps the most common scenario when novation arises is in the context of design and build projects, where the contractor takes entire responsibility for the design of a project. In this situation, the consultant is originally appointed by the client or the developer, and this appointment becomes extinguished and replaced with a new appointment between the consultant and the contractor. This slide seeks to demonstrate a very simple novation journey in relation to a design and build project. Initially, the client enters into an appointment with the consultant under which, for example, the consultant may carry out some preliminary design. In due course, the client appoints a contractor pursuant to a building contract, under which the contractor is responsible for the design and build of the project. As the contractor is responsible for the design, and the consultant has already provided preliminary advice to the client's appointment is then novated to the building contractor. There are two main approaches to novation in the design and build context: switch novation and ab initio novation. Each approach achieves different things in practice and generates different risks for consultants. For reasons which I hope will become obvious, consultants should always strive to achieve a switch novation. First, dealing with a switch novation. In this scenario, the consultant's appointment transfers from the client to the contractor at the date of the novation. This is what happens in reality. Prior to the transfer, the consultant provides work for the client, and post-transfer, the consultant then works for the contractor. The switch approach is that which is dealt with in the Construction Industry Council, or CIC, Novation Agreement. Pursuant to an ab initio novation, on the other hand, the transfer of the consultant's appointment to the contractor takes place as if the consultant had always been appointed by the contractor from the outset of the consultant's appointment on the project, i.e. when the consultant was first appointed to provide design services to the client. Ab initio creates this fiction. Ab initio in Latin means from the start, and the novated appointment applies as if it had always applied from the start of the project. This is a clear fiction, as when the consultant was first appointed in connection with the project, it owed its duties to the client and not to the contractor. We will come on to the problems and risks for a consultant arising out of these approaches shortly. Ben will be dealing with these. In Professional Services Agreements by Rachel Barnes, Rachel fittingly states that the nub of the debate about ab initio and switch novation agreements is really an argument about to whom and in respect of what should the consultant be liable in respect of services performed prior to the actual novation. I think this is a good summary of the source of the differences between the two approaches. This diagram seeks to demonstrate a switch novation. At the top of the slide is a timeline from commencement to completion. Between commencement and immediately prior to the date of novation, the professional appointment deals with the obligations, rights and liabilities as between the client and the consultant. From the date of novation until expiry of liability, the novated appointment will deal with the obligations, rights and liabilities as between the contractor and the consultant. There is a switch at the date of novation from the professional appointment to the novated appointment, and a clear line is drawn in the sand. This diagram seeks to demonstrate an ab initio novation. Upon entering into the novation agreement, the original appointment between the client and the consultant is extinguished, and the novated appointment applies as if it always had done since commencement, i.e. ab initio, which means from the start. Switch drafting and ab initio drafting can take various guises. In order to demonstrate typical provisions achieving these two novation arrangements, We have included on the next two slides clauses achieving a switch novation and clauses achieving an ab initio novation. The slide in front of us states achieving a switch novation, and I quote, "In respect of those services to be performed under the appointment that have yet to be performed by the consultant at the date of this novation agreement, the consultant agrees to perform those services for the contractor as if the contractor were a party to the appointment in place of the employer. The consultant shall have no liability to the employer arising out of the performance or non-performance of such services. In respect of those obligations to be performed under the appointment that have yet to be performed by the employer at the date of this novation agreement, the contractor agrees to perform those obligations as if the contractor were a party to the appointment in place of the employer. The employer shall have no liability to the consultant arising out of performance or non-performance of such obligations." This achieves a switch novation, a clear line in the sand. This slide contains drafting which achieves an ab initio novation. Again, I quote, "The employer hereby releases and discharges the consultant from any and all obligations and liabilities owed to the employer under the appointment. The consultant undertakes to perform the appointment as if the contractor were and had been from the inception a party to the appointment in lieu of the employer. The consultant hereby releases and discharges the employer from any and all obligations and liabilities owed to the consultant under the appointment and accepts the liability of the contractor under the appointment in lieu of the liability of the employer." This drafting achieves an ab initio novation, a fiction as to when the consultant was appointed by the contractor. I'm now going to hand you over to Ben, who's going to talk about the implications of novation, amongst other things.
Thank you, Will. I'll now talk in a bit more detail about some of the implications of novation and the issues which can arise, before looking at how some of these issues might be mitigated in practice. As mentioned by Will, novation may arise in various contexts, including, for example, a business sale or transfer between group companies. However, I will continue to focus on the issues arising in connection with D&B projects, as this is most commonly where consultants will come across novation, and where the more serious issues arise. In short, any form of novation represents additional risk for a consultant, and any obligation to novate should be avoided if possible. Looking at matters in more detail, there will be a number of legal and commercial considerations to be borne in mind. I'll look at some of these in more detail shortly, but typical issues include the extension of the consultant's liability, together with more practical issues, such as those relating to payment of outstanding fees or the identity of the contractor. Of the two forms of novation explained by Will, ab initio novation is generally regarded as being more onerous than switch, and more likely to result in greater risks for the consultant. It is important to note that a novation agreement may not use the terms switch or ab initio. However, it does not need to do so, and the effect of the novation will depend on the particular drafting used, and Will has already looked at some typical wording in earlier slides. The more onerous nature of the ab initio form arises from the extension of the consultant's liability to both client and contractor for pre-novation services, and the potential for a conflict of interest between duties owed on the one hand to the client and to the contractor on the other. If novation cannot be avoided, a switch novation, such as the CIC form, should be used if possible. This helps to avoid some of these issues and achieve a clean break between the pre- and post-novation services. However, depending on the terms of the novation agreement, Even a switch form of novation may expose a consultant to additional risks and may, in practice, have much the same effect as an ab initio novation. For example, the novation may provide the contractor with a right of recourse against the consultant in relation to the pre-novation services, or may require the consultant to warrant to the contractor that it has performed the pre-transfer services in accordance with the appointment. The wording of any such provision is important, and I'll look at this in the context of the CIC form on the next slide. As mentioned, the CIC form of novation agreement is a switch type. The consultant remains liable to the client for pre-novation services and is liable to the contractor for post-novation services. However, where the contractor takes responsibility for design under a D&B contract, this will typically include an element of the pre-novation services. The contractor will therefore want some protection against errors by the consultant in those services. The CIC form deals with this in clause 4a by the consultant warranting to the contractor that it has performed the pre-novation services in accordance with the appointment. This is the wording that is shown on the slide. Importantly, the consultant is warranting that it has performed these services for the client. This avoids the potential conflict mentioned above. To summarise the issues just discussed, I've included on this next slide commentary from Rachel Barnes, again taken from her book Professional Services Agreements, a guide for construction professionals. As Rachel mentions, the ab initio form does not make sense in reality. How can a consultant agree to this legal fiction that is always worked for the contractor? Up until the novation, the consultant is clearly working to the requirements of his client, and he should have only those interests in mind. The consultant has not in fact been employed by the contractor prior to the novation. He was under no duty to advise him as to the sufficiency of his tender, nor as to what contingencies or allowances should be provided for. In fact, had the consultant done these things, he may have been in conflict with the duties owed to his original client, and therefore acting in a manner adverse to that client's interests. I think this is a very useful summary and should be borne in mind when considering any proposed novation, particularly the ab initio form. As explained by Will, novation requires the consultant's consent. Therefore, it is important to bear in mind that if no obligation to novate is agreed at the outset and incorporated into the consultant's appointment, the consultant is under no legal obligation to agree to novation at some later stage. If a request to novate is made, it would be a commercial matter to be considered in light of the particular circumstances at the time of the request. If novation is proposed, whether in a draft form of appointment or otherwise, it is important to consider the surrounding circumstances to ensure the risks are understood at the outset and mitigated if possible. In a typical D&B scenario, where the intention is always for the consultant to be novated to the contractor, the consultant's appointment is likely to be prepared on the basis of this future novation, and therefore include the relevant obligation. However, if the project is not a D&B project, it is less likely to be appropriate for the appointment to include an obligation to novate. Any such obligation should be resisted. Otherwise, a consultant could find itself being transferred to a less desirable client, effectively against its wishes. At the time of the novation, refusal to novate is likely to amount to a breach of contract and could lead to further complications. Where novation is being proposed, it may be worth considering whether the client's objective, such as providing the contractor with direct recourse to the consultant in respect of any design issues, can be achieved in some other way, such as by way of a collateral warranty in favour of the contractor. If an obligation to novate must be included, you should consider qualifying it by expressly requiring the consultant's consent at the time the request is made, or by including conditions as to when the novation may occur, such as requiring all outstanding fees to have been paid, or the novation being conditional on the identity of the third party being acceptable, or their financial status being above a suitable level. The identity of the contractor is often likely to be unknown at the time the consultant is appointed. Whether the consultant's appointment is novated to a contractor or a replacement client, various risks may arise in relation to the identity of this third party. For example, the third party may not be in a financially strong position. It may present the consultant with a conflict of interest in respect of other projects, or it may be otherwise undesirable to contract with the third party, for example if there's been a history of difficult projects between the parties. Therefore, if possible, you should consider including conditions in the appointment relating to the identity and status of the third party to which the consultant can be novated. As noted, a switch novation would generally expose the consultant to fewer additional risks than an ab initio novation, but care should be taken as the agreement may not use those forms of words, and the nature of the novation may not be immediately obvious. Where a novation obligation is included in the appointment, the proposed form of agreement should be attached to the appointment to allow any issues to be considered at the outset. Where possible, consultants should insist on the use of the CIC form of agreement. It is the only form recommended for use by consultants and is endorsed by the various consultant bodies. As already noted, it also deals with the potential conflict of interests which can otherwise arise in the context of a novation. Sometimes appointments are silent as to the form of agreement, or simply refer to an appointment in a form acceptable to the employer. Such provisions should be avoided if possible, or qualified to give the consultant a right to refuse or to propose its own form of novation agreement, such as the CIC form. When considering the form of appointment, particular attention should be given to the terms dealing with payment. Novation agreements will typically state that the consultant acknowledges that all fees to date have been paid. This may well not be the case at the time the novation actually takes place, and I'll come back to this when I look at mitigation shortly. I'll now look at some of the key issues arising from the ab initio novation. As mentioned, ab initio novation is generally regarded as being more onerous than switch and results in greater risks for the consultant. An ab initio novation doesn't reflect the reality of a D&B contract. Instead, it creates a fiction that the consultant's client from the outset has been the contractor. This is not the case, and at the outset the consultant owed its duties to the client, not the contractor, and until the novation actually takes place, the consultant is working in the interests of the client. Importantly, he was not employed by the contractor to advise as to its tender price or similar issues. And in fact, had the consultant acted in this manner, it would have been in conflict with its duties to the client. However, the ab initio novation makes the consultant liable to the contractor as though it had been acting for the contractor from the outset. As a result, both the client and the contractor may have causes of action against the consultant for the pre-novation services, which can significantly extend the consultant's liability. Because of this fiction that the consultant has worked from the contractor from the outset, ab initio novation requires the consultant to tread a very fine line in order to balance the potentially competing interests of client and contractor. In practice, this is likely to be difficult to achieve, particularly at the outset when the consultant is working closely with the client, often well before a contractor has been identified. If ab initio novation must be used, the extent to which the contractor can recover for pre-novation breaches should be restricted. If possible, the agreement should limit the extent to which the contractor can recover for pre-novation losses, whether by including a limit on liability or adopting wording similar to that in the CIC form. As mentioned previously, a common way of providing the contractor with a right of recourse against the consultant is to include a warranty in favour of the contractor that the pre-novation services undertaken by the consultant have been performed in accordance with the terms of the appointment. Ideally, this would reflect the obligation to act for the client at this stage, as with the CIC form. If the consultant is in breach of the duties owed to the client, the contractor may sue the consultant to recover any loss suffered as a result. However, the warranty will often go further and warrant the consultant's performance under the appointment generally, or as though the consultant had always owed its obligations to the contractor. This does not reflect the reality of the situation, significantly extends liability, and should be avoided. Many innovation agreements include drafting to the effect that the consultant acknowledges that the contractor, in performing its duties under the building contract, has relied on advice and information provided by the consultant to the client under the appointment. For example, a typical appointment might state, "The consultant acknowledges that the contractor, in performing its duties under the building contract, as defined, has relied on the information and advice provided by the consultant to the client in performance of the services under the appointment prior to the novation of that appointment." This can create an additional tortious obligation to the contractor in respect of work done for the client. In addition, such an acknowledgement could limit the defences available to the consultant in the event of a claim, for example, in relation to causation and contributory negligence on the part of the contractor. If possible, such reliance provisions should be deleted, leaving the contractor to prove reliance in any claim. Note that such clauses may also appear in switch novations, in which case the same considerations apply. In order to prevent arguments that the contractor's losses are too remote and therefore not recoverable, novation agreements often include an acknowledgement by the consultant that any losses suffered by the contractor arising out of information and advice provided by the consultant to the client in the performance of its duties under the appointment were within the contemplation of the consultant at the date the appointment was entered into. However, this does not reflect the reality, particularly given that the consultant may have no idea who the contractor will be at the time it is in fact appointed. Such provisions further extend the consultant's liability beyond those matters for which it would be liable to the original client. If possible, such provisions should be deleted, again leaving the contractor to claim its losses in accordance with the usual principles of recovery. As above, such clauses may also appear in switch novations, in which case the same considerations would apply. I will now briefly summarise how issues arising in connection with novation could be mitigated. As mentioned already, you should try to avoid liability to the contractor for pre-novation services where possible, and any liability should relate to the services actually performed for the client, not as though they had been performed for the contractor. A novation agreement should provide for the release of rights and obligations between the original parties. Where a switch novation is used, the consultant should be released from liability to the client for any services provided post-novation. In the case of an ab initio novation, the consultant should be released from all obligations and liabilities to the client, on the basis that it will be liable to the contractor for all matters under the appointment from the outset. However, you should watch out for wording which releases the client from all obligations, including its obligation to pay, but releases the consultant only in respect of future liabilities. In these circumstances, the consultant could be liable to both the client and the contractor in respect of a single breach occurring pre-novation. Novation agreements often include provisions which prevent a consultant from arguing in defence of any claim that he should not be liable because the client has not suffered a loss. For example, an appointment may state, "The consultant may not assert that the contractor is precluded from recovering any loss resulting from a breach of the appointment relative to the pre-novation services on the grounds that the client, for whose benefit the pre-novation services were originally performed, has suffered no loss nor incurred any costs or expenses, or on the grounds that the client could not have suffered the loss or incurred the costs or expenses that have been suffered or incurred by the contractor. Such a provision makes the consultant liable for losses suffered by the contractor as a result of the consultant's breach of the appointment prior to novation, even if those losses would not have been suffered by the client. This means that, even if the form of novation is not ab initio, the consultant is still required to walk a tightrope prior to novation so as to avoid liability to either party. If possible, these provisions should be deleted, although this is a very common provision which the contractor is likely to insist on. Another important issue to consider is whether the consultant will have equivalent rights of defence post-novation. Where possible, it is helpful for a novation agreement to contain a clause granting the consultant the right to rely upon any limitation in the appointment, including any limit of liability, and to raise equivalent rights of defence against the contractor, as it would have against the client. This is particularly relevant in relation to the pre-novation services. Such a clause will reduce the risk of the novation increasing the consultant's liability, as it should ensure that any claim by the contractor is subject to the same limitations of liability and defences as a claim by the client would be. Naturally, any drafting restricting such rights should be resisted. Another issue to look out for in the appointment or novation agreement are variations to the underlying rights and obligations in the appointment. Sometimes novation agreements may seek to introduce variations to the underlying appointment, for example in relation to the basis on which the consultant would be paid, the scope of the services to be provided, or by introducing additional obligations. Such provisions will need to be considered on a case-by-case basis to determine whether they are acceptable and/or whether additional fees should be charged. A typical approach is to reject any variations to the underlying appointment, as this contains the parties' main obligations and liabilities and governed the relationship between the client and the consultant. Also look out for obligations to the contractor in respect of the building contract. Novation agreements may introduce an obligation on the consultant to ensure that the building contract, or programme, is complied with. Such an obligation could increase the consultant's duty of care and may amount to a fitness for purpose warranty, depending on the provisions of the building contract, or a strict obligation, for example in relation to any programme requirements. Where possible, such additional obligations should be deleted or qualified by reference to the duty of care required under the consultant's appointment. Any implied or express fitness for purpose obligations should be resisted. In any event, copies of the building contract, programme, and other relevant documents should be provided to the consultant prior to novation to ensure the risks can be assessed in advance. As a general point, you should watch out for indemnities. The novation agreement may introduce an indemnity in favour of the contractor or the client. Such indemnities can greatly increase the consultant's liability, as, in addition to being liable to the contractor in respect of pre-novation losses, they can result in much greater recovery than would otherwise be possible in a normal claim for damages. As a general rule, therefore, indemnities should be resisted wherever possible, and not just in relation to novation. Where indemnity provisions cannot be deleted, they should be qualified, such that the beneficiary of the indemnity has a duty to mitigate its losses, and is only entitled to recover its reasonable and proven costs resulting from the consultant's negligence. As mentioned previously, novation agreements very often include statements as to the fees position at the date of the novation. For example, the consultant acknowledges that all fees and expenses properly due to the consultant under the appointment up to the date of this deed have been paid by the client. The risk of such provisions is that the clause can operate to extinguish the consultant's claim for payment of outstanding fees. You should therefore ensure that all outstanding fees are actually paid prior to novation and, if possible, include a provision in the agreement to ensure that any unpaid fees can be recovered from the client or from the contractor. For example, the parties agree that from the effective date, all sums of whatever nature, whether arising before or after the effective date, due by the client to the consultant under the appointment, will be met in full by the contractor and paid to the consultant when said sums fall due for payment. In this way, the consultant will have a right to recover any unpaid sums directly from the contractor and will not have to pursue the client. Consideration should be given to the position in relation to intellectual property rights, generally, to ensure that both the consultant and the contractor possess the rights necessary to comply with their respective appointments. In addition, novation agreements, or collateral warranties, as I'll talk about below, may include provisions in respect of intellectual property rights post-novation, for example, granting from the consultant to the client a license to use certain rights for specified purposes. Such provisions should be considered to ensure consistency between the appointment, novation agreement, and building contract. On novation, a client may require step-in rights, whether in the novation agreement or in any collateral warranty to be granted, to ensure that it retains some control in the event, for example, of contractor insolvency. Where this is the case, it is common for the client to include restrictions on termination, although such restrictions may also be freestanding, often requiring advance notice of intended termination of the novated appointment. Where such provisions are included, they will need to be taken into account when considering termination of the novated appointment, and this is particularly important because they will not be immediately obvious on the face of the underlying appointment. If the consultant is required to provide a warranty to the client following novation, it may be liable to both the client and the contractor in respect of the same breach for post-novation services. This contrasts with the earlier position in relation to pre-novation services. Where a collateral warranty is required, the obligation should be set out in the appointment or agreed form of novation agreement, and the proposed form of warranty should be provided for review. Collateral warranties should be resisted if possible, as they generate an additional cause of action. However, it is fairly common for the client to require a warranty back from the consultant following novation. If a warranty must be provided, it should be carefully considered in the normal manner to ensure that it is consistent with the obligations in the appointment and does not extend the consultant's liability or otherwise contain unusual or onerous provisions. I will now hand back to Will, who is going to deal with the ongoing provision of services by the consultant post-novation before concluding the webinar.
Thank you, Ben. No talk on novation will be complete without a brief discussion on retained services. On occasions, consultants may be engaged by their client at the outset of a project to carry out project administration or monitoring roles, in addition to their design obligations. Where this is the case, the client will often require the consultant to continue to provide to it the project administration or monitoring services after novation. In addition, the consultant will obviously be providing design services to the contractor. I have to say this is becoming increasingly common. Such an arrangement gives rise to a number of practical issues. The main issue is the real prospect of a conflict between the consultant and its obligations to the contractor under the novated appointment and its ongoing administration or monitoring role to the client. For example, under a monitoring role, the consultant may have to assist the client in any dispute with the contractor. Moreover, there may be a scenario where the consultant is instructed by the contractor to vary its design, which the consultant knows will put the contractor in breach of the building contract, and in turn, the consultant must notify the breach to the client under its monitoring role. There are a number of approaches to deal with retained services within Novation documentation. The cleanest approach would be to have two separate appointments at Novation, one for the novated design services with the contractor and one for the retained services with the client, with appropriate conflict of interest and confidentiality drafting. However, from our experience, this is often rejected by clients for being overly complex. More typically, the obligation to carry out such retained functions may be included in the novation agreement or in any collateral warranty agreement between the consultant and the client. The latter is perhaps the most common. In relation to potential for conflicts of interest, these can be mitigated by the use of Chinese walls within the consultant organisation and or the use of dedicated staff or teams to carry out the retained functions, and drafting added to the Novation documentation to reflect this. In any event, it is important that the retained functions are clearly defined and separated from the functions which are to be noted in both the original appointment and then the Novation documentation. If you are to take anything away from today's webinar, it is that Novation in the design and build context presents additional risks for consultants which must be fully considered. If Novation cannot be avoided, the CIC Novation Agreement, which achieves a switch novation, should be used. Clients and contractors do agree to this form, and therefore do not let them tell you otherwise. As Ben has noted, the CIC form is the only one recommended to consultants and is endorsed by the relevant consultant bodies. Use of the CIC form means that consultants will be engaged on a proper basis and not in a position of conflict. Novation risks will also be mitigated. We are already seeing adjudications and claims arising out of the novation of consultants to design and build contractors. We believe that this will only get worse as time goes on and more projects are being carried out on a design and build basis, and also due to the effects of the recession and parties trying to recover the losses they have lost. So consultants, please be aware. So this has been a whistle-stop tour of Novation. Ben and I hope that our comments in this webinar have been helpful. As a follow-up, our colleagues Andrew Croft and Jennifer Webb will shortly have an article published in LexisNexis Construction Law discussing Novation and the things consultants need to consider. It's quite outspoken, so please look out for this. It will be placed on our website in due course, but if you would like a copy sent to you, please do email me or Ben on the details provided on the screen. I note that we have received a number of helpful questions. Thank you for these. I'll now hand you over to Ben, who will respond.
Thank you, Will. As Will mentioned, we've had a few queries in, so I'll have a quick look through these. One that we've got in asks, what happens if the novation agreement isn't signed? I think there's two ways of looking at this, and it really depends on the conduct of the parties. If the parties have effectively moved on and are behaving as though the consultant has been novated, Therefore, the consultant is working for the contractor, being paid by the contractor, and all parties effectively acting as though that is the situation. Then it's likely that a judge would find that there has been an implied novation, even if the underlying novation agreement hasn't actually been signed. Obviously, if the party's conduct was not consistent with the actual transfer having taken place, then it would be much less likely to find that the novation had occurred in that manner. The alternative that may arise would be if the consultant was holding off from signing the novation agreement, perhaps because of unpaid fees or other commercial reasons. Where that's the case, and the party's conduct clearly doesn't give rise to a transfer, then it's very unlikely there would be an implied novation, and this comes back to the need for consent in order to transfer obligations. Another question that's come in relates to the use of the CIC form, and Will's already touched on this. The question asks, is this form accepted on projects? And the short answer is yes, it is. And Will has already mentioned you shouldn't let contractors and developers and so on tell you that it isn't used. It is used on live projects. It's a sensible form of document and should certainly be pushed for if there's no form provided, or if the form that is provided needs further work to get it into an acceptable state. In addition, there's some useful drafting in the CIC form, and CIC also published some useful guidance taking parties through the various provisions, so it's often a useful port of call even if you don't end up using the agreement as a whole. Another question comes back to practical issues arising out of payment. I talked earlier about the payment provisions within novation agreements and the fact that these can cause practical issues by effectively deeming payment to have taken place even if that hasn't actually happened, and also perhaps restricting consultants from recovering fees down the line. In the context of a potential novation or perhaps a imminent novation, payment is really an issue to be sorted out between the client and the contractor. One of the parties should be paying you, and the best practical advice is probably effectively to make it the client's problem. They want the development to be progressed and to be built, and it's therefore in their interests to get this sorted. And this may be one of the examples where there's some commercial leverage to be exploited when looking at whether or not to sign up or when to sign up to the novation agreement. So effectively get the client to look at the payment issues, sort out with the contractor who's going to make the payment, but one of the parties will have to make that in order for the services to be continued. I think that deals broadly with the questions we've had in today, but if there's any others that come in, we'll deal with those directly in the emails. If you have any further questions, please feel free to email them through to the address on the website.
Thank you, Ben. It remains for me to say thank you for listening to me and Ben this afternoon. For CPD points, our SRA registration number is shown on the screen in front of you. In addition, you will see our contact details should you have any queries. Once again, thank you for listening. We will of course let you know of other webinars in due course. Many thanks and goodbye.